My name is Bob Charney, and I'm a lawyer with the Constitutional Law Branch at the Ministry of the Attorney General. And I'm going to be introducing the panel of speakers today and also be one of the speakers myself. The topics that we're going to be dealing with this afternoon are a variety of issues relating to the Charter of Rights, procedural issues, evidentiary issues, Charter Section 1, and remedial issues. And I think we have for you a terrific panel of constitutional experts. In the order that they will be appearing, starting on the far right, is Professor Ed Morgan, who's a professor at the University of Toronto Law School, teaches both constitutional law and international law. Prior to that, he was a lawyer with the law firm of Davies, Ward, and Beck. He has his LLM from Harvard Law School and was a clerk to Madam Justice Wilson. He has practiced extensively in the area of constitutional law, been involved in a variety of constitutional cases. The one that comes to my mind is the one that we were against each other on, which was the case of Adler against the Attorney General of Ontario, where Ed represented the Canadian Jewish Congress in an unsuccessful attempt to obtain funding for private religious schools. He will be speaking on, and I want to make sure I get this right, the constitutionalization of conflicts. All right, close enough. And the next speaker will be John Terry, who is a former colleague of mine from the Ministry of the Attorney General. John received his LLM from Harvard Law School and was a clerk, or former clerk to Mr. Justice Corey. After being with the Constitutional Law Branch at the Ministry of the Attorney General, John, for a short time, was at Cabinet Office, so he has a fairly broad spectrum of government experience. He then went off to teach law in New Zealand for 2 years and returned and joined the law firm of Tories, where he is involved in a variety of litigation, including constitutional litigation, and he's also teaches public international law. Then I will be speaking, and then the last speaker will be Chris Bredt, who has been on both sides of cases with me at various times. I'm never sure which side at what time, but Chris is a lawyer of the law firm, which I still know as Borden and Elliott, and he received his LLM from Yale and then a DSU from University of Paris. He was a clerk to Mr. Justice McIntyre, then joined Borden and Elliott, and then for a few years joined the government, where he was a director of constitutional policy, where he always likes to remind me that he was actually my boss for a couple of years, and then went off to become an assistant deputy minister in the Ministry of Intergovernmental Affairs. He then rejoined Borden and Elliott, where he's been involved in a number of constitutional cases. He was involved in the Levine case. He was counsel for H in the M&H case before the Supreme Court of Canada. And he also teaches both, he taught in the past advanced administrative law and is now teaching a course in freedom of expression at the University of Toronto Law School. So with that, what we're going to do is I'm going to ask each of the speakers to speak, and I think we'll hold off the questions until the end so that we can ask them at that point. So if we can start then with Professor Morgan.
Thank you, Bob. Always a good introducer and a sometime worthy adversary. Always a worthy adversary. Okay, as Bob said, I guess my fields are both constitutional law and international law. When Bob called me and asked me if I wanted to do something for today, he asked me if I would do something on constitutional law and procedure. Procedure, I had to scratch my head over that one a little bit just to figure out how to make it interesting for both me and for you. So I've come up with one topic I could think of that tries to combine all three of my interests. That is, my assigned interest in procedure and my interest in constitutional law and international law. I'm going to talk a little bit about the past 10 years and the Supreme Court of Canada's attempts to constitutionalize private international law or conflicts of law. And I'm going to try to do that through procedural cases. Let me start off by saying, as everybody does, all the constitutional scholars seem to say they either say that constitutional law is a conversation about society, or possibly more typically they say constitutional law gives you a snapshot of society and its politics at any given moment. A snapshot of society, I can say because I've read the quotes, Peter Hogg says this, my colleague David Beatty says this, Alan Hutchinson says this, Lawrence Tribe says this about American constitutional law. It seems to be sort of the accepted wisdom of the field that constitutional law gives you a snapshot of society. And that is I take that to mean, at least in one sense, that the link to politics is a thick one. That is, the law, constitutional law, is not always 100% rational. I think if you think about our federalism cases over the history of Canadian federalism law, think about the wide swings we've had from sort of broad provincial powers in the 1920s and 1930s in the Privy Council's jurisprudence to the 1970s and the expansion of federal powers, you would say it's not 100% rational, but the link to politics is a thick one, and that it gives us a snapshot of the political constellation of the country at any given moment in time. I want to take a few minutes this morning, and what I've tried to do in the paper is challenge that thought just a little bit. No, it's a soft challenge. What I really want to say is not that constitutional law is not political. It would be very hard to do a serious analysis, I think, of our constitutional history without thinking something about the politics of the Privy Council's 1930s support for provincial powers in the face of federal labor legislation, or the 1970s and the expansion of the economic powers. Bor-Alaskan's anti-inflation reference judgment and the expansion of federal economic powers. It would be hard to understand that without any understanding of the politics of the times. But what I really want to say is that constitutional law does not photograph well. If what you really want is a picture of a nation, you're going to get something that's very blurred. And I say this typically, it's not that it doesn't, as I say, it's not that it isn't political, it's that it presents a moving target. Our politics tends to be complicated. It's always on the move, and constitutional law comes along supposedly to give us a snapshot. It's trying to freeze a moving target. Not only that, our constitutional jurisprudence is itself complicated and always on the move. So what we have in this snapshot, I think, is a picture of a moving target from a moving platform. It's bad photography. Now, with that introduction, let me get into some procedural cases. As I said, I don't think it would be interesting for this audience to give you a procedural how-to talk about constitutional law, but I do think it is interesting to think a little bit about what we do when we subject procedural rules to constitutional analysis. It tends, when doing that, tends to focus our attention on the workings and the structure of the legal system itself. So that's what I'm interested in doing today, looking at the constitutionalization process of the legal system. Okay, and in particular, I want to look at constitutionalizing rules that come out of civil procedure. I think we have lots of experience with constitutionalizing criminal procedure rules. That's a very special case, I think, of a direct confrontation between an individual and his or her rights and the state as the adversary. But constitutionalizing rules of civil process is a kind of a more diffuse and generic way of looking at the legal system itself and asking what it is that we're trying to take a picture of when we take that constitutional snapshot. In the past 10 years, and in particular in the judgments, it's really from the late 80s until the mid to late 90s in the judgments of Justice Laforêt, the Supreme Court of Canada has gone a long way towards constitutionalizing the rules of conflicts of law. That is to say, the Supreme Court did a lot of reform in this field, changing and modifying the common law rules of conflicts in order to fit the constitutional environment in Canada. And they have said, in so many words, that many of the rules that we have now fashioned out of common law rules are constitutionally required in Canada. The high point of the leading case, the one that everybody cites for this phenomenon, is the 1990 decision in de Savoy against Morgard. This started off a very interesting phenomenon, something I don't think we had seen much of prior to this, and that is cases that raise federalism problems, raise the federalist structure of the Constitution, but that are outside of the framework of Sections 91 and 92. All these conflicts of law cases are not Section 91, 92 cases as we traditionally understand that to be. So, for example, in the Morgard case, the court read a so-called full faith and credit requirement into the Canadian Constitution. If you read most of the critics, they say read the full faith and credit requirement into a silent constitutional text. That is, in the United States, they have a full faith and credit clause in the Constitution so that the judgments of sister states have to be honored by each other. We have no such clause in the Canadian Constitution, and the Supreme Court read it in. Now, I would say if you read the Morgard decision, what you will see is that the Supreme Court read the full faith and credit requirement not into a silent constitution. What it did is it read the full faith and credit requirement into a constitution that expressed this idea, they said, everywhere. It expressed it, for example, that is, they found it in the deep structure of federalism, to use Justice Laforest's words. He found it implicit in mobility rights, implicit in trade and commerce, implicit in all of the clauses that make Canada a political and economic union. Okay, so he found it in, as I said, the deep structure of federalism that's embodied in the entire Constitution. More on the Morgard case later. Let me look at a couple of actual procedural cases. The first one I want to look at is a case called Hunt against TNN. This case the Supreme Court decided in 1993. It's an interesting case. So the case raises what at first strikes me as a quirky procedural question. That is, can one bring a constitutional challenge to a piece of provincial legislation in the courts of a different province, not the province that enacted the legislation? What we had here was a Quebec statute that whose constitutionality was challenged in a British Columbia court. The statute was a so-called blocking statute enacted by Quebec with respect to production of corporate documents in out-of-province litigation. It prohibited the production by Quebec companies of documents to parties in litigation if the litigation was in non-Quebec courts. It was aimed, and you can see the Supreme Court finds this in its judgment, and this is clear, it was aimed, as a matter of policy, it was aimed by the Quebec legislature originally at United States antitrust cases, the extraterritorial reach of U.S. antitrust law. And so it was meant to protect Quebec companies who found themselves as defendants in antitrust cases from the United States. It prohibited them from producing corporate documents to the American plaintiffs in the antitrust cases. Comes up, though, here in British Columbia legislation. A British Columbia company is suing a Quebec company, and the Quebec company tries to invoke the Quebec blocking statute. Now, just as an aside, this goes up to the Supreme Court of Canada basically as a case of first instance, which I find, just being a little bit interested in Canadian history, I find that remarkable that it's quirky, but it's remarkable that in the 1990s you have this question as a case of first instance. Somehow it shows, if you want my penny's worth of political economy, it somehow shows the extent to which sort of the direction, the flow of services, goods, people, and their disputes that go with them has been north-south in this country and not east-west, or north-south from this country and not east-west within the country. But in any case, the Hunt case explicitly raised two issues. One, substantive one, that is, does the Quebec legislature have the power to do this? And secondly, a procedural or jurisdictional one, that is, can the Quebec statute be challenged at all in British Columbia? I want to talk about those two the decisions on both fronts in a moment. Let me just remind you, though, because this is implicit in the judgment, of two historic images of the Constitution that we typically carry around with us. If it's not carried around in the front of our minds when we do constitutional law, it seems to be carried around in the back of our minds. These two historic images, I think, that arise out of Canadian constitutional law are, first of all, the Constitutional Compact. This idea that autonomous, insular provinces came together in a contract-like arrangement in 1867, much like a treaty arrangement. If you look at the 1867 Confederation debates, this idea was typically expressed by Quebecers. But of course, we see traces of this in our Constitution. Certainly in the BNA Act, you see traces of this in language rights provisions. You see traces, certainly clear traces of this thinking in denominational school rights, which are typically described as a pact between Upper and Lower Canada. You see traces of this currently in the 1980s in debates in the amending process. And I believe you see traces of this in the jurisprudence. It certainly goes a long way to explaining the Privy Council's 1920s and 1930s jurisprudence that talked about the watertight compartments, etc. That is the constitutional pact. It evokes to me the image of a nation that, as it were, is held together at the seams. Okay? It's really no greater than the sum of its parts. It's a contractual arrangement. That's vision number one. The second historic vision I think we all carry around about Canadian constitutional law is the vision of overarching constitutionalism. And you would see this too if you looked at the 1867 debates. The people who trace their constitutional theory to Dicey and the English rule of law. Federalism in this view, federalism gets equated with the dominance of legal principle over local politics or over regional politics. And I think also you see a lot of this in the constitutional text. You see this in interprovincial mobility. You see this in trade and commerce. You see this in the terms of union, and you certainly see this in the secession reference. You also see it very strongly, if you look back through the case law, in the 1950s implied Bill of Rights cases, if you recall those cases. And as I said, I think you see this also in the 1970s expansion of federal economic powers. I would think that the judges that stand for this most strongly are probably Justices Rand and Justice Laskin, historically. Anyway, here's two historic visions of Canadian constitutional law, both of which I believe are alive and well today. That's as opposed to our neighbor to the south, who also, in the first 100 years of their constitutional existence as a nation, had a similar debate. It was in slightly different terms in the United States, but in American constitutional history, you have a historic debate between the so-called Constitutional Compact and what John Marshall called popular sovereignty. And this, for 100 years, went back, or almost 100 years, went back and forth in the courts. Marshall championed popular sovereignty, and if you think about Marbury and Madison, the sort of great-grandfather of judicial review, you can see a Dicey-like judgment in Marbury and Madison. Right, the supremacy of constitutional principle over inappropriate administrative actions by the executive branch. And then, of course, the Constitutional Compact was championed by the southern states and the states' rights advocates that they had on the court, all of which kind of culminated with Dred Scott and ultimately the Civil War, which resolved the issue. Popular sovereignty clearly is the governing sort of image of constitutionalism in the United States. We haven't had our Civil War yet. So the judicial struggle continues, and I think that both visions are truly alive and well in Canadian case law. Anyway, there's a little diversion into history. Back to the Hunt case. The substantive ruling, let me do this in reverse order. I'll do the substantive ruling first and then the jurisdictional one. The substantive ruling said, basically, the Supreme Court of Canada said that the provinces are equal to each other. They are insulated from one another. So the Quebec legislature cannot act in a way which invades BC jurisdiction. And they said you have to take the words of Section 92 seriously. Property and civil rights in the province, and they italicize in the province. That means that the Quebec legislature has to keep its blocking statute to itself. Okay? British Columbia has its own litigation rules. They call for production of documents. Quebec can't reach into British Columbia and impose its own rules of non-production of documents on British Columbia civil process. Okay, so the two, and this is the compact vision, the two equal provinces have come together in this constitutional pact. And one can't invade the regulation of civil rights in the other. Okay, so we strike down Quebec's long arm and protect BC's civil process. Then we move to the jurisdictional issue. Can this constitutional point even be litigated, even be raised in a British Columbia court? Now, this is an interesting discussion. The answer to this raises an interesting discussion in the Supreme Court's judgment. What the Supreme Court says is, they ask rhetorically, what are the superior courts of the provinces all about? What is their jurisdiction? Now, we know that they are courts of inherent jurisdiction. And what the Supreme Court says is that they are not creatures of the provinces at all. They are the inheritors of the inherent jurisdiction of the English Court of Queen's Bench, or historically Court of King's Bench. And that explains, of course, why it makes sense for the judges of the superior courts of the provinces to be federal appointees. And it explains why, since the 1860s, we have case law that says that the superior courts of the province are courts of inherent jurisdiction and are bound to apply all the laws of the land, including, and I would say especially, the Constitution. So what the Supreme Court ends up saying is that although they sit in different provinces, we have effectively a unitary judicial system in Canada. Okay, now, the United States, has done this through a very expansive federal jurisdiction, federal court jurisdiction. You would have these constitutional challenges always in federal court. I wouldn't be able to give this paper in a conference in the United States. It would take too long to explain. But what they end up saying is that Quebec can't complain about any one of the superior courts in Canada applying the Constitution to it. Okay? That is, we live in a country unified by a single constitution under one normative umbrella. That's the essence of confederation, says the Supreme Court. So they switch gears and they go to the overarching constitutionalism vision of Canadian constitutional law. Two visions coexist in one judgment within pages of each other in the Supreme Court reports. One more procedural case from the Supreme Court of Canada in the conflicts of law field is a case called Spencer. Spencer raises the problem of the right against self-incrimination. Now, the right against self-incrimination has been a difficult problem, in particular with respect in conflicts of law, in private international law, in particular with respect to people who have to testify in Canada pursuant to letters of request or letters rogatory coming from the United States, where there are potential criminal proceedings pending in the United States. Okay, and the problem derives first and foremost from different applications of the right against self-incrimination. Our right basically derives from Section 5 of the Canada Evidence Act. That is, it tends to be interpreted as a right against so-called derivative use of your testimony. Your words in one proceeding can't be used against you in a subsequent criminal proceeding. Now, of course, the Charter also prohibits the Crown from calling an accused person as a witness in her own trial, in the very criminal proceedings in which that accused person is on trial. But here we're talking about the problem of two proceedings, a civil proceeding followed by a criminal one. In the United States, the Fifth Amendment works in a different way. You have a right, of course, to refuse to answer the incriminating question in the first place. But if you don't plead the Fifth Amendment, as they say, you might find it used against you later. It's not at all clear that you have the same derivative use right as we find in the Canada Evidence Act. My understanding is that that's why they spend so much time in negotiations over immunity deals. Monaco will plead the Fifth if Ken Starr doesn't do something that assures her immunity from prosecution subsequently. She doesn't have the Canada Evidence Act rights to fall back on. Anyway. So the interesting question that the courts have been very perplexed about is what happens when a person has to testify in Canada under letters rogatory, but criminal proceedings may be pending in the United States. You don't have the Fifth Amendment right here, and you don't have the Section 5 Canada Evidence Act right when you get down there. It's a difficult question which the courts actually have been consistently ducking. That particular hard one hasn't gotten to the Supreme Court of Canada. What has gotten there is a case called Spencer. Now, this we've addressed in the same exact place, a similar problem we've addressed in the same place that the United States courts have addressed this for 30 years now, and that is the problem of bank secrecy jurisdictions. I think Spencer's probably the typical case. The manager of the Freeport, Bahamas branch of the Royal Bank of Canada is compelled to testify in Canada as a witness, not as an accused person, as a witness. His testimony will potentially subject him to criminal proceedings in the Bahamas. It will violate Bahamian law, the disclosing of bank information. The court gives two answers to this problem. Does he have to testify, or does he have a right to self-incrimination? They give two answers. They make sense. Doctrinally, those two answers go together, but I would argue that conceptually they're quite contradictory. First of all, they say the constitutional right applies inside the country, not outside the country. Basically, they say each country has to go it alone. We, of course, would never prosecute him for something in violation of his for something in violation of his Canadian constitutional rights, but we can't do anything about a potential prosecution in a foreign country. Right? So every place has its own rules, and you subject yourself to multiple rules and possibly contradictory rules if you travel and move through multiple jurisdictions. They then switch gears in an interesting switch inside the judgment, and they adopt the U.S. rule on point. The U.S., as I said, has considered this in a whole series of cases over the years. They express the same concern as the American courts have expressed for tax enforcement, drug law enforcement, and international cooperation that all of that leads to today. What they say is that we need the same rule that the U.S. has adopted towards tax havens and bank secrecy countries because we're all in the same war against money laundering and tax evasion and international crime, etc. So the international economy and the international underworld economy, the international criminal economy, have all put us in the same boat. We all have the same policy interests. A few more minutes. To understand that, 5 minutes of diversion, and then I'm going to wrap up. To understand that, I just want to go for a minute back to Morgard and the full faith and credit requirement. Full faith and credit was a distinct departure from the English common law. Right? At common law, you had to sue on the foreign judgment. We gave no faith and no credit to a foreign judgment. Laforet said that the change in Morgard, the change in the common law, was based on the fact that the common law was now obsolete and inapplicable because it grew out of the history of England. Right? And most importantly, it's inapplicable because of the distinct nature of Canada. Now, Laforet did this in a number of cases. He did it in a case called Libman in the mid-'80s with respect to international or extraterritorial criminal jurisdiction. He did it in Tollefson with respect to the choice of law in tort, and he did it in Morgard with respect to enforcement of foreign judgments. He traces the historic roots of the common law rule and explains how this was clearly an outgrowth of English history. It all comes from a couple of things. It comes from the unitary nature of the English legal system. It comes from England's position as an island, literally both sort of geographically as an island and legally as an island, separated from the continent with a completely different kind of legal system. And it also comes from England's position as an imperial power trying to manage a diverse empire with different legal cultures out there. And we didn't give full faith and credit to any foreign judgment. Laforet says we're very different, though, from England. And he finds the difference, as I said, in the deep structure of Canadian federalism. We've all come to live together under one sovereign, normative, constitutional umbrella. This is what I've called in the paper a sort of judicial narcissism. And I don't say that pejoratively. I like this idea. But it's, in the Narcissus myth, a youth looked into a pond, saw the reflection of someone who he became infatuated with, and it turns out to be himself. This is what Laforet is doing here. That is, he spends page after page after page after page talking about England. In fact, what he's infatuated with is Canada. Okay? Now, when he does this, I would say, if you had to put a political gloss on this, his politics clearly, to me, have a strong echo of Trudeauism, Trudeau federalism. Right? We are not, as between ourselves, the provinces, we're not isolated and insular jurisdictions at all. We're not in the same relationship as international states are to each other. We're one big bilingual, bicultural, bilegal family, all under one umbrella. We're a big, distinct society vis-a-vis England and the other countries out there. Okay, it's this constitutional structure, though, that sets us apart from other countries and that's where he finds the requirement of full faith and credit. Sister provinces have to give each other full faith and credit. At the same time, for those of you who are interested in anything to do with international trade, you'll know that Morgard is the case where the Supreme Court of Canada recognized the new economy and globalization. Right? So you go to other passages of the Morgard judgment, and what you find is that the common law is not obsolete because it comes from England and wedded to their history. In fact, it's obsolete because it's dated. It's simply out of date. The new economy of the 20th century has made the jurisdictional structures of the 19th century irrelevant. So now, today, the name of the game in the global economy is to facilitate the flow of goods, the flow of services, the flow of people, and I suppose, yes, in Morgard, the flow of judgments across borders. And if you don't believe me, true to the point, the first thing that happens after the Morgard case is decided by the Supreme Court, this case that supposedly stands for the distinctness of the Canadian constitutional structure and how different we are than all the other countries, the first thing that happens after Morgard is that all the other courts in the country start applying it to U.S. judgments. Right? We start enforcing U.S. judgments with full faith and credit. When you read these passages of Laforet's judgment, you can hear in all his language with respect to economics and the new economy, you hear distinct echoes of Mulroney. Now, this is a case that arose in the late 80s in the heart of the free trade debate. What we're really talking about when we talk so much about Canada and its position in the world is Canada and our position in the flow of progress and globalization. He says we have to stay competitive and open our borders. We have to let down all our national barriers. And we have to do this in all respects as part, especially as part, of the big North American economy. This is, I would say, as I called it in the paper, it's a sort of reverse narcissism. That is, we spend page after page after page talking about Canada, and what we're really infatuated with is the United States. And this is true, you see, this is true in terms of international cooperation in law enforcement, see this in Spencer, and it's true in international economic integration, which you see in Morgard. So everywhere you turn, even to what look first like little procedural questions, constitutional analysis throws up different political images of what the country's really all about. We are a compact among equal provinces, and we are a country that has submitted to an overarching constitutional umbrella. We're a distinct nation with its own constitutional character, and we're a globalized nation integrated with and having the same character as our trading partners. It's all that movement back and forth that makes the constitutional snapshot of society a blur. The Constitution seems to be constantly in motion, and in particular, when you come to civil process, all you get is process in process. Wrap up. Thank you.
I'm John Terry. I'm going to be using the overhead for my talk. I don't know what it's like for those at the back to see it, but if you want some assistance in the Materials tab 10 at the back of my paper there, these slides are reproduced there. Now, I'd like to begin my talk with the somewhat provocative statement that Section 1 of the Charter, which I'm sure most of you are intimately aware, is the most important section of the Charter. And some of you will say, well, equality is, freedom of expression is, maybe the right to move across provincial barriers is. I say Section 1 is because, for one thing, it's the section that no matter what charter right you're dealing with a few exceptions, you end up, if there is a violation, coming to Section 1. In many cases, as you know, all the reasoning is really about Section 1, page after page after page, and the actual analysis about whether the right's violated is only a few pages. Perhaps for me, the most interesting and important thing, though, is Section 1 is where the courts and the legislatures are working out the balance, or it's the court that's trying to work it out, but it definitely has the legislature and Parliament in mind when it's trying to do so. And you can see the court in so many of these areas squirming to figure out what the appropriate level of deference is to give to Parliament, to give to the legislature. And that's continually being worked out under Section 1. And unlike some of the other rights that will be defined more or less into the future, that's really an unsolvable problem where you're going to see Section 1, the courts, trying to work out the relationship with the legislature and looking at the objectives underlying the legislation versus what the courts are doing. Third is Section 1 is a unique Canadian innovation. Before Section 1, we have, of course, the US Bill of Rights that has absolute rights, and the courts have to go about making their compromises between the legislative objective and the right under the right itself. And we had the European examples, the European Convention on Human Rights. We had also the International Convention on Human Rights, but all those have particular Section 1 type clauses that were attached to the right in question. So this was our contribution to international constitutional jurisprudence. And in fact, if you look, at least in the Commonwealth, at the constitutions adopted since our constitution, or since the Charter, in the New Zealand Bill of Rights and in the South African Constitution, we see Section 1 equivalents. And not only that, but it's sort of like with the Microsoft Windows, you get the web browser, you tend to get the Oakes test as well in these jurisdictions. With Section 1 comes your Oakes test, although you do have the choice as to whether or not you want to adopt it. So despite the fact, though, despite the importance of Section 1, what you see all the time is counsel not really paying all that much attention to Section 1 until you're pretty late in the game. You've gathered together a lot of your evidence, and you're in the midst of the trial, or you've been putting together all your social science affidavits. And in many cases, not in all, but in many cases, Section 1 is more of an afterthought than the actual issue as to whether the right's being violated. And what I want to talk about, and my talk is a little bit of a how-to talk, although I think I have certain spins and analysis that will make it of interest to you. But what I want to talk about is really how you go about controlling the Section 1 analysis as counsel. And I want to do that by looking at examples of how the court has dealt with Section 1. This set of slides comes through a sort of a process of refining an article that myself and a colleague named Tim Macklin did, which has been published recently, which takes a sort of a long critical look at Section 1. The speech is more of a refinement of that, focused on really how counsel can go about controlling Section 1. And the key thing for me in understanding Section 1 is the distinction between the variables that go into Section 1, the Section 1 analysis, and the formula itself. The three variables that go into the Section 1 analysis are the objective of the legislation, the means, that is a particular legislation, the statutory means that have been adopted by the legislature or parliament to carry out this objective, and the right itself. And it's important to keep those variables in mind, because you've got to remember that when you go about characterizing those variables, whether you are a lawyer or the court, there's got to be a consistency in the way that you characterize those variables. If you say, for example, for one thing, if you're trying to argue that there's been a right that's been violated, and you say the objective is one thing there, then you've got to be consistent, and you've got to use the same definition of the objective when it comes to the Section 1 analysis. As I'll be showing you, it's critically important how you go about characterizing each of the objective, the means, and the right. Now, the three variables get plugged into the Oakes formula, with which I'm sure everyone is familiar, the four parts. Is the objective sufficiently important? Is the means rationally connected to the objective? Does the means impair the right as little as possible? And does the objective's importance outweigh the severity of the violation of the right? You can see that in all these formulas, all you're really talking about in terms of variables are the three different variables. They show up in each one of these: objective, means, and right. There are no other variables in that analysis. And the key one, of course, is the third part of the Oakes formula, the least drastic means test. And when Oakes first came out in 1986, many commentators were quite surprised at the stringency of the third part of the test, because the way that Oakes was characterized there was as a test that would apply to all violations of charter rights, no matter how serious. And this third test, the least drastic means test, was the test that had been adopted in the US for the most serious violations of rights. So there was some interest in the fact that the court had adopted the most serious test that would apply to all rights. But as you'll see, what the court has done and what lawyers can do is, in characterizing these three variables, they've characterized them in ways that bring flexibility to the test. So it's not quite as stringent as one might have thought. And the second thing that's been done is the test itself has been altered, particularly the third prong of the test. So we've got two approaches, which I'll get to later, and I call my paper the deferential approach and the contextual approach. And those approaches have been used to water down the third part of the test, to make Oakes a lot less stringent than it otherwise would be. So let's start with the variables. The first variable to define, and perhaps the most interesting and the one that really allows the most flexibility, is defining the objective of the legislation. Now, as you'll know, there are restrictions in doing that. You can't, as the courts have said in the jurisprudence, you've got to have a consistency when you're defining the objective in terms of the right. That's got to be consistent with the objective under Section 1. You can't go and use a post hoc objective. Like the Big M drug mart case back in 85, if the law was brought in for a religious purpose, a Sunday closing law, you can't later on say it was brought in for the purpose of just providing a day of rest. And there are other limitations in the objective, but the bottom line is you have quite a bit of flexibility when it comes to defining the legislative objective. And this is where I think counsel on both on the government side of the case and the side challenging the government have sometimes the most difficulty trying to come up with the right definition. You want the objective to be something that is going to pass the pressing and substantial test. It's got to be sufficiently important to override a right. But you also want it to be defining the objective with an eye to the proportionality analysis that you have to go to under the second and third parts of the test. So this is an example that I like to point to of the prostitution reference in 1990. It was a case concerning the constitutionality of criminal code provisions that prohibited communicating for the purposes of prostitution. Now, in this case, all the members of the court found a violation of freedom of expression. And then they went on to the Section 1 analysis. And the first one I have is actually the dissenting reasons of Wilson. In that case, it was Wilson and Lura Dubé in dissent. And you can see when she defines the objective, she defines it as a social nuisance arising from the public display of the sale of sex. And she goes on in her description to really emphasize that the concern is with the public nature of prostitution, of communication for prostitution. Now, the means that were adopted here, the legislation, wasn't just limited to places that were out in the open for everyone to see. It could apply to solicitation that was going on in parks, you know, in bushes, in areas where anyone in the public had access. So under her analysis, she defined the objective in a broad enough way that when it came to the means, you knew that the third and the second part of the Oakes test will be satisfied, that the means were not proportional to the objective, because the means went and intruded into areas where you wouldn't really see the public sale of sex. Now, Dixon avoided this problem when he defined his objective. It's a more amorphous definition, with the public at large, with the environment represented by streets, public places, and neighboring premises. His objective is more, it's a little bit like Giuliani's sort of broken windows approach, that if you allow prostitution to go on in one particular area, then it's going to spread and influence its way through the streets. So he defines his objective in a way that captures the means, the legislative means that are adopted, and deals with the fact that the means extend into places that normally wouldn't be out in the public, because it has a sort of amorphous effect in public areas. And Lemaire takes a different approach. Lemaire also, like Dixon, upheld the legislation under Section 1. He focused on the fact that the legislation was designed to deal with and to protect a vulnerable group, women, from exploitation. What he did in this way is he actually took it a step further. Instead of just matching the objective to the means, he was able in this way to change the way that the Oakes test was applied. Because, as I'll be getting to in a moment, one of the ways in which the court applies a more deferential Oakes test is when there are vulnerable groups, when the legislature is trying to protect vulnerable groups. So he was able to say, the legislature is protecting vulnerable groups, therefore we should defer to them. Now, another example of this is in the Equality Trilogy of 95. And a couple of the cases here, Miron and Trudel, which was a case that came up from Ontario about same-sex spouses and whether they were entitled to claim under insurance, in auto insurance. And the second one, the Egan case, of course, was a case about claiming same-sex spousal pension benefits. And you can see here again this attempt by the different sides to align the objective with the means. And this was done, by the way, not only under Section 1 in this case, but under Section 15, because the Section 15 equality test adopted here by a number of the judges was one that required you to look at whether the basis of discrimination was relevant to the legislature's objective. So in this case, you'll remember that the legislation gave rights to claim under auto insurance only to spouses who were legally married, not to common law spouses. The objective Gontier says is it's to help those couples who are married. And that's kind of the end of the game right there. When you get to the means, it's on the basis that people are married. So clearly the means is going to fit the objective. McLaughlin defines it as sustaining families when one of their members is injured. The broader use of the word families there means that she is able to find that the means don't match the objective, because the means provide assistance to married people, not to common law spouses. And you can see the same thing under Egan. Laforet defines the objective of supporting heterosexual couples with the capacity to procreate children. Corey and Iacobucci talk more generally about the mitigation of poverty among elderly households. So clearly, the Corey and Iacobucci definition shows that if that's the objective, then the means that are chosen, which grant the benefits only to opposite-sex couples, are clearly not going to meet the objective. So the objective, the definition of the objective, offers a lot of opportunities for judges to, let's say, manipulate or influence the Oakes test, but it really offers an opportunity for counsel to come in first and to try to define that objective in a way, and define it both in the rights analysis and later on in the Section 1 analysis in a way that's going to support their case. Now, the means is a little more difficult to characterize in variable ways. In many cases, the legislation is going to be what it's going to be, and there's not going to be all that much you can do to change it. But there's one example in the Keegstra and Taylor cases, which dealt with hate propaganda. In both those cases, the Supreme Court used a characterization of a means that ended up assisting that judge in justifying the limitation under Section 1. What happened in that case is that Chief Justice Dixon gave words like hatred and contempt and the promotion of hatred, which were the key words in the section, their narrowest possible meaning. And this allowed him to be able to say that the means had been carefully tailored to fit the objective. Now, the downside of that, if you're acting for the government, is you want to be thinking about, in other cases, whether you really want to be putting a narrow definition on your criminal code or your statutory provision, because obviously that's might hurt you down the road when you're trying to prosecute other people. But in that case, if Dixon hadn't done that, it left him open to the attack that the means here did not fit the objective. And that's what McLaughlin did in that case. She emphasized the breadth of the provisions, the fact that words like hatred and contempt were extremely broad and very difficult to define, and because of that would not satisfy the third part of the Oakes test. And one of the interesting things when you look at this analysis is you'll know that the court generally does not, the remedy of reading down, the court is often reluctant to use that remedy except in limited purposes. But what this approach actually amounts to is a reading down, a preemptive reading down, because Dixon has read down the provisions, giving them a narrow meaning in order to justify them under Section 1. I mean, the other approach he could have taken was to say that the provisions were not justified under Section 1, but then read them down to reach that scope. And this is a sort of preemptive reading down. Now, the third variable is the right. And again, there's going to be very little that can be done in terms of the definition of the right. But it's worth keeping this in mind to see the way that the definition can influence the Section 1 approach. Freedom of expression, for example, very, very broad definition of the right. What it means is that you almost always go to the Section 1 analysis. Section 15 is a little more interesting. After the Andrews case in the late 80s, you had a relatively broad definition of the right under Section 15. You had to have disadvantage, and it had to be on the basis of a ground that was listed under Section 15 or analogous to that ground. So generally, when you found a violation, you would be, because it was a broad provision, it would be easier to find a violation and then go to justification under Section 1. What you've had happening, though, through the mid-90s is you've had the courts adding extra qualifiers to the Section 15 analysis. You have the judges in the Miron and Egan cases, Laforet, Gontier, and others, adding the irrelevant distinction provision that the distinction has to be irrelevant in addition to satisfying those other provisions. And then in the law case, you have the addition that the distinction has to violate essential human dignity. And what you find then is that more and more you get the justificatory analysis, the Section 1 analysis occurring under Section 15. And this has a couple of effects. One is that it shifts the burden of proof. The burden of proof is always on the challenger with respect to whether the right's being violated, and shifts to the government under Section 1. So this keeps the burden of proof with the challenger. And it often also leads to a less rigorous Section 1 analysis. So those are the three variables: the objective, the means, and the right. All three of which, particularly the objective, can be, if they're carefully characterized, they can be characterized in a way that again can assist you in your case. Now, the deferential approach is the first of two approaches, the deferential and the contextual approach, where we're not talking about changing the variables, we're talking about actually altering the formula, the Oakes test formula. And the focus here is on the third part of the test, the least drastic means test. Now, the rationale the courts adopted for the deferential approach is one really of lack of institutional expertise. The court has said, in these cases, we're going to defer to the legislature because we don't have the experience or expertise to make these judgments. And what you get under this deferential approach is two types of Section 1 scrutiny. The first one, the stringent one, in the traditional cases, like a criminal law case where the state is the antagonist to the individual rights holder. You've got the big state there, you've got the individual rights holder, and you've got a conflict between the two of them. You get the lesser scrutiny in two cases where the state is mediating between competing interests. So you've got social economic legislation, you've got different interests advocating different results. The state is mediated between those. Or you've got a situation where the state is protecting vulnerable groups. Now, this deferential approach grew up almost immediately after Oakes, and really the next key Section 1 test case after that, the Edwards Books case, the Sunday closing law case. The court adopted this deferential approach and then spun it out in subsequent cases. It can be criticized on a number of bases. First of all, it creates really a hierarchy of rights, so that rights that arise in a social-economic context are given less weight than other rights. And you saw that perhaps most graphically in the Egan case, where Sapinka in the Section 1 analysis characterized that legislation involving and the decision to give pension benefits to opposite-sex spouses and not same-sex spouses as an example of socioeconomic legislation that required deference from the courts. So you see there an example where you can get a hierarchy of rights. And you also have the protecting vulnerable groups, a very laudable goal, and you can perhaps tie it into a theory of judicial review, but the problem again is, where do we really find in the Charter a basis for distinguishing between cases in which the government's protecting vulnerable groups and the government's not protecting vulnerable groups? So the problem with both those cases is it really creates a hierarchy, but when we look to the terms of the Charter, we don't really find a basis for creating that hierarchy. But perhaps most important of all, it's a highly manipulable distinction that is made between legislation that's mediating between competing interests and legislation that has the state as antagonist against the individual rights holder. And the courts have recognized this. McLaughlin in the RJR McDonald case explicitly recognized this. There are cases that I mentioned in my paper, a number of criminal law cases where some of the judges have said, well, this is clearly state as antagonist situations, and the other judges have said, well, no, it's actually the state as a mediator. And I guess the lesson for counsel is to adopt the reading that is appropriate for your particular case. Because this deferential approach remains there. The court in all the cases subsequent and up to the most recent Charter cases still talks about the mediating between competing interests and protecting vulnerable groups. And as I mentioned at the bottom there, what happens to the test, the less stringent test, is that the legislature need only have a reasonable basis for concluding it had used the least restrictive means. So it's a much more deferential approach than the court's actually saying it is the least restrictive means. Finally, then, we have an approach called the contextual approach. This has a different rationale than the deferential approach. At least arguably it does. What the court is doing here is actively intervening in these cases and saying, this is a case where we don't think the right is as important, the right violation, so we're going to use lesser scrutiny. as opposed to the deferential approach where they're deferring to the legislature. And this, I'm running out of time, so just to briefly emphasize, the key here is that you look to the right in question and the nature of the violation of the right to determine how serious the violation of the right is. The problem that the courts often fall into here is they give lip service to this contextual approach. It's sort of a lovely postmodern word to throw in, so they're always saying, well, look at this in context, look at this in context. But it becomes meaningless if you don't tie it to the actual purpose of the right in question. So I think the most persuasive way to use this contextual approach is you look at the purpose of the right. For example, freedom of expression. You look at the underlying values of the right, you look then at the violation, and you can make a strong argument from there as to whether or not the particular violation is a serious violation of the right. So just to wrap up then, with that quick tour d'horizon, the key thing, keep the two parts separate. Look at the variables, then look at the formula, and prepare well in advance for Section 1 arguments, because the worst thing is to be halfway through the trial when you realize that you've got this argument to make. Thanks.
Thank you. I think my comments follow nicely after John's in that I'm dealing with evidence in charter cases, and in the focus of my paper, it's my wrap-up sign. I get the hook as soon as I stand. It's like the Supreme Court. The focus of my paper and of my comments today are what kind of evidence you can use to prove legislative purpose. And as John has explained, legislative purpose is, of course, central to the Section 1 analysis of any charter case. And it also becomes very important at the very beginning of a charter case, especially when you're dealing with freedom of expression or equality, as to what the legislative purpose is, because the first part of the Section 2 test is the purpose to limit freedom of expression. The first part of the Section 15 analysis is to look at the purpose of the law. And so legislative purpose becomes the focus of each aspect of the charter analysis. And the question is, how do you prove legislative purpose? How do we know what the purpose is? And I think John has given you some great examples, and there are others in my paper, where the courts, looking at the same material, have come to very different views as to what the purpose of the law is. And part of the focus has to be, how do we decide what that purpose can be? And I want to direct some of my comments to an issue that has come up in a number of cases lately, and that is whether you can actually call cabinet ministers or political staff or civil servants and cross-examine them and try and find out what the purpose of the legislature is by examining those individuals. And I think that's a particularly interesting issue, because if you could do that, it would have the potential to, I think, be a dramatic change in the nature of constitutional litigation, and would have the potential to politicize the court in a way that charter critics have yet not even imagined. So first of all, let me deal with what are the admissible forms of evidence to prove the purpose of legislation. And I think these are now fairly well established. In the first place that you look, and it isn't really evidence, but the first place that you look is the plain wording of the statute. What does the statute say? What does the particular section that's being challenged state? Is there a preamble in the statute? And of course, looking at the statute as a whole to find out what the purpose of the law is. And sometimes, very often, the purpose is obvious just from a reading of the statute. And you really only have to go further if there's some ambiguity or some question after having looked at the plain wording of the statute. The next source that courts look to determine the purpose of the law is Hansard, the legislative debates. And these are often hit and miss in the sense that there aren't always legislative debates dealing with the statute that's being considered, or more significantly, the section of the statute that is being considered. Usually, there will be a statement by the responsible minister at the time that the legislation is introduced for second or for third reading, and the minister will give some suggestion as to what the purpose of the law is, or the mischief that the law was aimed at. They may even deal with particular sections of it, and particular sections, the purpose may come out in the context of debate. Sometimes you're quite lucky. I mean, sections that are challenged are controversial, and so there's a lot of legislative debate on those sections. Other times, there may simply be nothing. The courts, although they accept Hansard debates as a source for determining purpose, have been very cautious in dealing with Hansard debates, and they've talked about the limited reliability in Hansard debates. And the courts weren't born yesterday, and so they understand that sometimes you have to take comments that politicians make with a grain of salt. And the concerns that they have in particular is, number one, the intent of a particular member, even the member introducing the legislation in the House, even the responsible minister, may not reflect the corporate intention of the legislation. And that's why, for example, if there's a conflict between what's said in the House and the plain wording of the statute, it's the plain wording of the statute that governs. Because at the end of the day, it's the plain wording of the statute that represents the corporate view of the legislature. And so that limitation has to be observed whenever you're looking at Hansard debates. The other point that the court recognizes is that Hansard debates are often comments that are made in the context of often a heated political debate. And people may say things in the context of these debates which seems like a good answer at the time, but on reflection isn't necessarily even their own rationale for supporting the legislation. And so because these are done in a political context rather than a legal context, they have to be approached with some caution. The other evidentiary source for determining legislative purpose are the broad category of government reports. And usually these do not exist, but sometimes you're fortunate and they do. And there may be, for example, a Royal Commission report. There may be a Law Reform Commission report that predates the legislation. There may be government white papers. And these reports often give some indication as to the mischief that the legislation was aimed at. And so the courts have found these reports very helpful in assessing legislative purpose. And sometimes, I mean, the legislature obviously isn't bound by a Royal Commission report or a Law Reform Commission report or even a government white paper. And so sometimes the statute may not adopt some of the recommendations in these government reports. And you can often glean a lot of information from the differences between what the reports say and what the legislation ultimately did. And so those are all areas that can be looked at. Now, one of the difficulties in assessing purpose, and I think you even saw it a bit in the slides that John Terry provided you with, is that the court tends to spend its time trying to figure out what the purpose of the law is, as if there is a single purpose. And usually, there isn't. Usually, legislation is never the product of a single purpose that the legislature has and they drive to the wall. Usually, legislation is the product of multiple, somewhat competing purposes, sometimes conflicting purposes, that lead to certain compromises. That's the political element of legislation. And often what happens in the course of constitutional litigation is that people challenging a law will, for example, say, this is the purpose of the law. And this is what this section does. This section does something that is inconsistent with the purpose of the law, and therefore it's irrational under the Section 1 analysis. And of course, that's easy to do if there was ever a single purpose to legislation. It's easy to find sections that conflict with the purpose and are therefore irrational, but that's because the legislation wasn't the product of a single purpose. It was a product of multiple purposes that led to compromise. And so the sections that appear to be in conflict really further a different purpose that was one of the several purposes of the legislation. And the courts, of course, have started to recognize, I think, that that is true, and that what the legislature is doing is balancing purposes. when they pass legislation. In the Supreme Court of Canada, in the M&H case, Justice Iacobucci recognized that when he was looking at the Family Law Act. And the question, of course, in the M&H case was whether the definition of spouse in Part 3 of the Family Law Act, which established support obligations for married and common law spouses, whether it violated Section 15 and could be justified on the basis of Section 1 because it did not include same-sex partners. And there was some dispute as to, why did it not include it and what was the purpose. And Justice Iacobucci said the following, which I think is an important point. Often legislation does not simply further one goal, but strikes a balance among several goals, some of which may be in tension. And I would go farther than often. I would say almost always that's true. And when I do a Section 1 analysis in the context of any factum that I've done, I very rarely have a single purpose. I usually indicate what the several purposes of the legislation would be and why the compromise is, and it makes more sense that way as well. Let me go to the question of inadmissible evidence. And before I start this, I have to make a disclosure to you, and that is I'm now involved in a case where the very issue of whether or not you can call a minister of the Crown to testify is an issue that is under appeal. And so the analysis that I'm going to give you, although entirely objective, happens to be consistent with the position I'm taking in court. And just the case, the background of the case is a year or so ago, the Ontario government canceled the spring bear hunt in Ontario on the basis that they said that it led to the mistaken orphaning of bear cubs. And when bear cubs are orphaned in the spring, because they don't have a mother, they're dependent on the mother, they starve to death, and it's a very inhumane death. And the hunters have gotten together and have argued that freedom of expression guarantees the right to hunt bears in the spring. And no, I see people laugh, but I'm not making this up. And in the context of the judicial review, the Council for the Hunters, the Ontario Federation of Anglers and Hunters, has served a subpoena to cross-examine both the Minister of Natural Resources and the Premier for the purposes of trying to cross-examine them as to their reasons for canceling the spring bear hunt. And they served the subpoena. We were successful in having the subpoenas quashed on the basis that it was irrelevant, and that decision is now under appeal. Just on the point of the merits, I just want to point that our position is going to be that if freedom of expression guarantees the right to hunt bears, then we are going to give the bears guns to defend themselves on the basis that if freedom of expression guarantees the right to bear arms, it should also guarantee the right to arm bears. Dealing with the first case where this arose was the case Peel against A&P Limited, and that dealt with the constitutional validity of the Retail Business Holidays Act, the Sunday closing law, one of a series of cases dealing with Sunday closing. And the case was originally before Mr. Justice Southey, and the issue in the case was the government had recently amended the law to provide for a local option. This was about 10 years ago, where they changed the law so that stores were closed on Sunday, but local municipalities could opt out, in effect, and have stores opened if they wanted. And the lawyer for A&P, or one of the parties, served a subpoena on the Honorable Greg Sorbera, who was the Minister of Labor at the time, and on Joan Smith, who was the Solicitor General, who was responsible for bringing the amendments into the legislature. And Justice Southey allowed the subpoenas. The government brought a motion to quash the subpoenas. Justice Southey allowed it, and they were allowed to testify. And Justice Southey, the decision, I understand, was an endorsement. It's not reported anywhere, but I think the basis of it was that if Hansard is admissible, then why shouldn't we get to cross-examine the ministers of the Crown as well? And I wasn't counsel on the case, but I actually did go to watch, because I thought this would sort of be a unique thing to watch ministers being cross-examined in court. And in the course of the cross-examination, Greg Sorbera was asked a question about something he had said in the legislature, a point which I will mention briefly. I think also violates principles of parliamentary privilege, but I'll go back to that later. But Greg Cerbero was asked a question about a statement he had made in the legislature, and his answer, which I thought eloquently summarized the whole problem with admitting this kind of testimony, was that statement, he said, was more rhetorical than it was analytical. And I think that really summarizes the difficulty with admitting this kind of evidence and asking cabinet ministers, what did you mean when you said this in the House? In any event, the evidence was admitted. It then went up to the Ontario Court of Appeal, and Justice Southey, I should say, invalidated the law. Then on the merits, it was appealed to the Court of Appeal, and the Court of Appeal allowed the appeal, both upholding the validity of the legislation, and in the course of his reasons, Justice Finlayson, speaking for himself, not for the whole court, was very critical of the notion of calling ministers of the Crown to testify about why they supported legislation. And I'll just read to you what Justice Finlayson said. He said, under what would have to be considered legislative evidence, the respondents led testimony of ministers of the Crown as to the purpose and effect of amendments to the Act and the Employment Standards Act. In my opinion, it was improper to subpoena ministers of the Crown to give testimony at a hearing such as this. It is a usurpation of the legislative process to call as witnesses the ministers who introduced the amendment to these statutes into the legislature and have government legislation stand or fall on their testimony. These ministers are not the legislature. The respondents appear to have thought that they were entitled to treat both Mrs. Smith and Mr. Cerbero, both ministers of the Crown, as if they were officers of a corporation involved in private litigation. The issue arose again in a case which by coincidence happens to have been decided by the Court of Appeal just yesterday, and that was the case of the Ontario Teachers Federation against the Attorney General, and that was a case in which I was one of the counsel. In that case, you'll recall, in October 1997, there was, the government was introducing amendments to the Education Act called the Education Quality Improvement Act. The teachers' unions were opposed to those amendments, and so they called what we like to call an illegal strike, what they like to call a political protest, to oppose the legislation. That was in October of 1997. And in the midst of the illegal strike political protest, the government amended the Education Quality Improvement Act, Bill 160 then, to take principals and vice principals out of the teachers' bargaining unit and make them, in effect, the on-site managers. And there had been a history of this issue for 25 years in Ontario as to whether teachers or principals and vice principals should be part of the bargaining unit, should they be the on-site managers. And in the previous legislation, a compromise had been reached. They were permitted to be part of the bargaining unit, or they were mandatory members of the bargaining unit because it's a statutory bargaining agent. At the same time, though, they were prohibited from participating in any strike. So in the midst of the illegal strike or political protest that the principals and vice principals participated in, the government said, enough, you're out of the bargaining unit, and introduced the amendment. That was challenged by the Ontario Teachers Federation, and they took the position that the amendment was a reprisal to punish principals and vice principals for participating in political protest, exercising their constitutional rights. Government's position was no. The purpose of the law was not a reprisal, but it was a recognition that they were principals and vice principals who were in a conflict situation, that they had to be made either bargaining unit members or management, and that they were more appropriately management. At the beginning of the litigation, the Ontario Teachers Federation subpoenaed both Minister Johnson, who was the Minister of Education, who was responsible for introducing the amendment, and Guy Journo. And those of you who were at Pat Monahan's Charter Watch conference in April now know who Guy Journo is, and he was at the time the chief of policy in the Premier's office. And they wanted to subpoena these people to cross-examine them as to why the amendment had been introduced into the House. We brought a motion to quash the subpoenas, and the argument on the one side was that because they were alleging that this was a reprisal, they had to know what the motive of the minister in introducing the legislation and the motive of the Premier's office in supporting the legislation was, and they should get to cross-examine them. And we said, no, at the end of the day, what matters is the validity of the legislation, and you're looking at the corporate purpose and not motive of individuals. And Justice Blair agreed with us and quashed the summons, really on two grounds, one being that it is the intention of what he called the incorporeal body, known as the legislature, not of its individual members or those who supported the legislation, which is pertinent to the court's efforts. And the second one was that permitting cross-examinations of cabinet ministers in court would in effect turn the court into an extension of the legislative floor, and that it would overly politicize the courts. And he was very careful to distinguish between individual motive, on the one hand, the motive of individual members for voting or supporting legislation, and the purpose of legislation, which again is something that you have to look at the words of the statute to determine what that is. And of course, individual members of the legislature may have a number of motives, personal motives, for supporting legislation. We know we have a system of party discipline, and often individual members may support legislation because it happens to be, or oppose legislation because it happens to be consistent with the position of their party. They may support or oppose legislation because they want to get reelected, something that politicians desire. Ultimately, though, it's our position that those are political issues, they're not legal issues, and so they're not the kinds of issues that courts should be assessing in a determination of what is legislative purpose. And Justice Blair said, you know, you can look at Hansard, you can look at government reports, but it would be an unwarranted extension of those principles to start cross-examining and looking at individual members to determine what their personal motive was. This analysis, we think, was I think approved of by the Court of Appeal in its decision yesterday. Justice Gouge, in his decision, said, expressions of motivation by individual government actors must be scrutinized to see that they truly reflect legislative intent, rather than simply individual concerns. The former are appropriately part of the charter analysis. The latter are left to be sanctioned at the ballot box. So the court has made a very careful distinction between where law ends and politics begins. I see I've got the wrap-up sign now. So what I'm going to briefly do is there are a couple of Supreme Court of Canada cases that I think support that analysis. They're referred to in the paper. One is the case of consortium developments against Sarnia, where the court agreed that there had been subpoenas against members of the municipal council to cross-examine them to determine why they voted for a particular resolution. And the Supreme Court said, we're not interested in why individual members vote for something. We're interested in the words of what they voted for, and we can determine validity by looking at those words, not by assessing individual motive. Another case is Delisle against Canada, where again the court said, we're not interested in individual motive, we're interested in the purpose of the law. And the Supreme Court makes the point, if you were concerned about motive and not about the words of the act, you'd have a strange situation where if the Parliament passes a law with an improper motive, the court could strike it down, and then they could pass exactly the same law and somehow manage to hide their improper motive, maybe, you know, be a little less candid in the House or something like that. And the Supreme Court would have to uphold the exact same law with the exact same words. And they said, that doesn't make any sense. We're concerned with the words, not with the motive. And then at the end of the paper, I very briefly looked at the question of parliamentary privilege, which is a constitutional principle in Canada. One of the parliamentary privileges, I'd submit, although I don't know that it's been directly considered by a court, is the notion that you cannot question a member of the legislature or member of parliament outside of the House or in any court proceeding about what they've said in the House. And it would be a violation of that principle to subpoena members of the House to testify as to why they voted for legislation or why they said what they said. Thank you.
I'm not in a very enviable position here. The last speaker, at the end of a long day, with three great speakers in front of me, and in these circumstances, I'm going to try to take to heart what Mr. Justice Esty once said about advocacy. He said, remember the 3 B's. Be prepared, be brief, and be gone. I hope to satisfy you on at least the latter 2. Before I get started, I want to just thank Tamara Barkley, who assisted me on the paper that you have before you. She did an awful lot of work pulling that together and deserves a fair amount of the credit. My topic is constitutional remedies, and what I've done is to, first of all, to try and outline the test that the Supreme Court established in the Schachter case, and then secondly, to raise the problem of retroactivity, which is a problem that the Supreme Court didn't consider in any detail in Schachter, and in my mind does merit some consideration. First, dealing with the Schachter case. This is the case that really sets the framework for constitutional remedies. It's a 1992 Supreme Court of Canada case, and in essence, what it does is set the framework for interpreting Section 52 and Section 24 of the Charter. Section 52 is the section that says, basically, to the extent of any inconsistency, that there's a statute that gets passed or regulation that if it's inconsistent with the Constitution, it's of no force and effect. And Section 21 is aimed more at individual remedies and gives the individual the right to apply to a court for an appropriate remedy in circumstances where their rights under the Charter have been infringed. Turning just quickly to the facts in Schachter. What happened in Schachter was, under the Unemployment Insurance Act, maternity benefits were available for biological families, but only for the mother. And there was a provision that made available similar benefits for adoptive families, and they were made available for both the adoptive mother or the adoptive father. So Schachter decided that he wanted to have the same type of benefit that was being made available to adoptive fathers, and he brought a challenge before the federal court in that regard. And before the federal court, Mr. Justice Strayer said, Schachter, you're right, your Section 15 rights have been violated here, and the remedy that I'm going to give you is to extend the benefit to you. And that became a very important remedy, because from the federal government's perspective, there were a lot more working men out there who might now take advantage of the benefit than there were working women who could take advantage of the maternity benefit. And they were concerned that, to some extent, the courts had stood the program on its ears and extended the program to a far larger group than the program was originally designed for, and it was going to cost them a whole whack of money. So that the appeal went to the federal court, and the federal government, before the federal court, essentially just conceded the constitutional violation, but raised the issue that the court was acting inappropriately, in effect that they were engaged in appropriations of money for programs and extending programs where they ought not to. So with that as a framework, it came before the Supreme Court of Canada. And the Supreme Court allowed the appeal, and in doing so, they set out a framework for analysis. The first thing that the court did in that decision is to identify the types of constitutional remedies that might be available. And they identified 3 remedies in particular. First of all, striking down the legislation with or without a temporary suspension. Secondly, you can sever the provision, or you can read down the provision, and there is a difference between the two. And finally, you could read a remedy into the statute. Dealing with striking down the legislation, it's important to note that striking down results in the case being determined as if the provision in question never existed. And the fact that I'm going to deal with a little bit later on is to emphasize the retroactive nature of that type of remedy. And a good example is the Vren case. The Vren case is a case where the Alberta Human Rights Code had no protection for discrimination based on the basis of sexual orientation. And after that provision was read into the remedy, that affected discrimination that might have occurred well before the provision formed part of the statute. So that people who were discriminating on the basis of sexual orientation would not have known that that was in the statute because it was read into the statute by the court. And it's important to note that if the court strikes something down but then suspends its declaration, the retroactive effect is ameliorated. The second type of remedy that the court talked about was severance or reading down, and I think it's important to emphasize that the two are distinct. Reading down is available where there are a bunch of different possible interpretations of the statute, one of which might avoid any sort of constitutional problems, and others which would create constitutional problems. And in those circumstances, the court says, well, we'll read this statute so as to avoid the constitutional problem. Severance, on the other hand, is where the court says, well, look, there is a problem in the statute, but we can get rid of the problem by severing. It's more like a scalpel-like approach. We're going to take out the provision that's causing the problems. Now, the third type of remedy the court identified was reading in. And there had been some debate about the ability of courts to read provisions into legislation, again on the basis that they're usurping the role of the legislature. It's for the legislature to write the legislation, and for the courts to start reading in material is to step beyond the appropriate bounds. And the court says, well, that can't be the case because, in essence, severance is the flip side, or reading in is the flip side of severance. Severance relates to something that is wrongly included, and thus you can sever it from the legislation to cure the defect. And reading in, to some extent, relates to something that was wrongly left out or excluded, and the result may be to read in the provision or include an excluded group. And the court says, well, in a number of cases, that's a remedy that we have to have in our arsenal. Otherwise, you're going to deal with the problem of equality with a vengeance. In other words, anytime a challenge is brought to public benefits legislation, if the only remedy that's available is to strike down the legislation as a whole, you take the benefit away from a deserving group and provide no benefit to the group that was wrongly excluded. Having set out the remedies that were available, the court then turned to a framework for analysis as to how you choose the appropriate option. And here, what the court said is there's a three-part test. You have to first define the extent of the inconsistency. Secondly, you have to determine whether severance or reading in is appropriate. And finally, you have to determine whether the declaration of invalidity ought to be temporarily suspended. Turning first to defining the extent of the inconsistency, what the court says is, in order to do that, you have to look at the Section 1 test. And John Terry took you through that. I won't take you through it. Basically, what the court said is, look, if you can't even satisfy the first part of the test, that's the legitimate objective, then basically the remedy that the court should be looking at is just striking down the legislation as a whole. On the other hand, if you've satisfied that first part of the test and you're coming to the second part, which is the rational connection test, that tends to speaking to striking down that part of the legislation that is not rationally connected to the objective. And then finally what the court says is, well, if you've got through those first two parts of the test and you're really in the minimal impairment or the proportionality test, those are the types of areas where you should start looking at severance and reading in. Now, the second part of the test then, which they then turn to, is how you determine whether severance or reading in is appropriate. And again, the court has three factors. One is remedial precision. The second is interference with legislative objective. And thirdly, the change in significance of the remaining portion. Dealing first with remedial precision, what the court said is that there's an important distinction between severance and reading in. Severance, the court can be much more precise because they're going to just take one part of the statute out versus reading in, which involves much more speculating as to what the legislature might have done had they been aware of the constitutional problem. Turning to the second part of the test, the interference with the legislative objective, what the court says is if the legislative objective is obvious, then sometimes severance or reading in, if it would further that objective, you can go ahead and use the remedy. In circumstances where that is less obvious, then it's less appropriate for the courts to adopt one of those remedies. Secondly, if the choice of means used by the legislature is not unequivocal, again, it might be unacceptable intrusion into the legislative area. And finally, severance or reading in should not involve an intrusion into legislative budgetary decisions. And again, what they're coming back to there is to the extent that the change that is being read in is going to have a significant effect, then that's an important factor for the court. The third part of this test is the change in significance of the remaining portion. And sometimes if you're reading in, and clearly they were foreshadowing what they were going to do in the Schachter case, if the size of the group to be added is much larger than the original group, then you may well be altering the thrust of the program, and you should leave it to the legislature to sort out the change. Now, turning to then the last question, which is whether to temporarily suspend the declaration of invalidity, what the court said here is that it's really a serious problem for the court to have declared something as unconstitutional, but to leave it in effect. And they said they're suspending the constitutional declaration is appropriate in circumstances where there's a danger to the public, where it might threaten the rule of law, or in circumstances where the legislation is deemed unconstitutional because of under-inclusiveness, and therefore striking down the legislation would take away benefits that clearly the legislature intended to make available to a particular group. Having set out the analysis then with respect to Section 52, the court turned quickly to Section 24 and said, how does Section 24 work in the context of Section 52? And they say, generally, Section 24 remedies are not going to be available where Section 52 remedy is granted. That is, if the law is struck down, there's no longer an infringement, therefore you wouldn't give an individual remedy. If the declaration is suspended, then generally also not available because, in effect, you would retroactively make it available in the circumstances and circumvent the purpose of suspending the declaration in the first place. So the end result in Schachter was legislation struck down. In this case, it was easy for the court because the legislature had already amended the statute. No suspension was necessary. They said in that case reading in was not appropriate, and there should be no Section 24 remedy for Schachter. Let me turn quickly then to the issue of retroactivity. The reason I raise retroactivity is because of the basic distinction between legislation and judicial decisions. legislation is presumed to operate prospectively, whereas judicial decisions operate retroactively. They operate on facts that occurred prior to the judicial decision. And it's a basic presumption that retroactive legislation is to be avoided, and the rationales for that are obvious. You know, we all have to have some predictability in our life. We base our decisions based upon our expectations of the law as we know it at the time we act. And if someone comes upon later on and says, hey, I know you expected the law was going to be this way, but we're going to change it, it's unfair. And it operates against settled expectations. Now, Schachter didn't talk much about retroactivity, and there are a number of techniques that the courts can use to deal with the problem. One of the techniques that I set out in my paper is prospective overruling. That is, people assume that the decisions of the courts have to operate retroactively. That's not an assumption that's accepted, for example, in the United States. And the courts there have, in certain circumstances, say, look, what was done previously is unconstitutional. We're going to change it, but we're only going to change it for the future. And I note in the paper that that is quite similar to what the courts do when they declare something unconstitutional, but they suspend the declaration. Because in both of those cases, the individual that brought their constitutional case before the court goes away without a remedy. And, you know, one of the difficulties in these circumstances is people will say, well, look, here's someone, they took the case all the way to the Supreme Court of Canada, they were right, they got the law changed, but they don't get to benefit from that. And so what I look at the end of the paper is the question of, okay, in what circumstances and what are the types of considerations does the court have regard to in determining whether or not to apply something retroactively? And in this regard, I say, well, an important factor is who's going to bear the burden of the change. Is it going to be the general public, or is it going to be particular individuals? And I make reference to a principle from French administrative law, where in French administrative law, basically they have a concept known as égalité devant la charge publique, and that concept means equal bearing of public burdens. And applying that to constitutional law, what I say is, well, if you're going to change the law, and it's in the public interest to change it, then the burden of the change should be borne by the public as a whole and shouldn't fall on the shoulders of one or two particular individuals. And the example I give to illustrate the point is distinctions between public benefits legislations and legislation that regulates private relationships. Take Egan, for example. Egan was a case that dealt with benefits available under the Old Age Security Act. And same-sex couples were denied those benefits. That's a case where if you're going to change the law and extend the benefit, the burden of the change is borne by the taxpayers as a whole, which is appropriate in the circumstances. It doesn't fall on the shoulders of one individual in particular. And I think it's important to contrast that with a case like M&H. M&H dealt with Family Law Act, which regulated private relationships between individuals. And in that case, my client H had started a relationship in 1982, well before Section 15 ever came into effect. And they had entered into a number of contractual relationships with respect to property and so forth. And Section 15 comes into effect in 1985. Depending upon whose versions of the facts you accept, the relationship breaks up in around 1987, and it's now 1988 or 1998, 1999 when the court decision is made, and all of a sudden the court's saying, well, we're going to change the rules upon which the relationship was based when it first started. That's an example where the burden of the change is really being borne by individuals who had settled expectations about the law that was going to govern the relationships at the time the relationships began. Just to sum up quickly then, I think that Schachter does provide some useful guidelines. I think that one thing that the Schachter case didn't look at carefully is the problem of retroactivity, and I've made some suggestions for some of the types of factors that courts ought to consider in determining whether they're going to make the remedy retroactive or not. I think I'll shut it down there. Thank you.
I think we still have 5 minutes for questions, so if anybody in the audience has any questions for any of the speakers. Yes, there's one there. I think that's interesting because in those, how does my doctrine of the relevance of motive or legislative motive jive with the doctrine of colorability, where the court is saying that, again, a law which on its face might be valid would be invalid because it really has an improper purpose. And I think there the distinction is that the colorable purpose is a colorable legislative purpose as opposed to an individual motive. And I understand the point, and it's a good one, and that's how, in fact, the OTF case was argued, that this is really colorable legislation. But that the court still has to distinguish between the purpose of the law and the motive of individuals. And when a law is struck down as being a colorable attempt to, either if it's federal law to colorable attempt to invade provincial jurisdiction or the other way around, or in the context of the charter, you're still looking at the purpose of the legislation as a whole. And it would be a very difficult thing for courts to do, and it may be, it's more of an art than a science to that extent. It becomes less relevant in the context of the charter because, of course, in the context of the charter, the court is looking at both the purpose and the effect of legislation. And so in the charter context, even if you can't prove a colorable purpose, if the purpose of the law was colorable, even if you can't prove it, likely it's going to have an improper effect. And so you can always prove the effect, and so you can get at it that way. But I think that's a good point. Any other questions? Yes?
If there's an assumption of bad faith on the acts of the legislature, is it the result of the cases you give it that you really can't bring that out by way of subpoena?
Well, when you say a presumption of bad faith on the part of the legislature, as opposed to individual members or as opposed to the person that introduced it, I mean, the answer is, I don't know how you could say that the legislature was engaged in bad faith, except to the extent, as the question asked before, about colorability.
There's an analogy in municipal law. Municipal councils have been held to act in bad faith.
But again, it's the council as a whole as opposed to individual members. And the Clearwater case that I referred to, Clearwater against Sarnia, Consortium Development Clearwater against Sarnia, again would indicate you can't cross-examine the individual councillors to determine whether they were acting in bad faith. What you're ultimately looking at is the resolution that was passed and whether the terms of that resolution are consistent with the law. Okay. Yes, Anita.
In terms of your piece on parliamentary privilege, one thing that you don't address, and often these questions of the legislative intention arise in terms of some kind of interpretation of that statute, which is clear on its face. Now, I'm wondering, since so much of the legislative drafting is done in committee, and you don't mention that, whether your view is that any concept of parliamentary privilege extends to the committee meetings, because I don't remember Maginot covering that. And, you know, it's clearly not the usual kind of situation where the discussion is in the House or part of the business like the House of Commons.
No, you know, and I don't know the answer to that. I mean, my initial reaction would be that even if they're in committee, they're still in the House speaking as members of the legislature, but I don't know the answer to that. Any other questions for somebody else? No? Okay. Pretty well over at this point in any event. I'm supposed to remind you that at 4 o'clock we are to have a reception just across the hall, and everybody is invited. And then just to conclude, I'd like to thank today's panel for their presentation.